Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
Welcome to the Lex Rex Institute podcast. I am your acting host,
What?
Eric Hampton. New voice on the podcast.
Oh gosh, David's got to run for his money.
Yeah, let's see if I can muster up a little bit of talent to rival his. I am the Vice President of Marketing for the Lex Rex Institute, and of course, I am joined by our lawyer supreme, Alex Haberbush.
Yeah, that's right. I'm your co-host, Alexander Haberbush. I'm president of the Lex Rex Institute and also a practicing constitutional attorney, although I won't be speaking in that capacity today or ever on this podcast.
It's a good point to note that nothing in this podcast is constituting legal advice, even though we have a lawyer on here.
Just because I am a lawyer and you're listening to this podcast does not mean that I'm your lawyer.
And definitely don't take legal advice from me. I just have a nice smile and can make things sound nice. So the opinions of all the individuals expressing them are not necessarily those of the Lex Rex Institute. They are of these individuals exclusively.
That's right. And making stuff sound nice is really a skill, Eric, because lawyers aren't very good at that. You know, we're used to calling things like first amended complaint against, and then you list all the defendants and you say what all the causes of action are. There's a reason that people don't typically read the actual legal documents and just read articles about them. So we very much appreciate what Eric does here. He'll make things sound great on this podcast. Yeah, Lex Rex Institute, for those who don't know, is a nonprofit constitutional advocacy organization. If you'd like to learn a bit more about what we do or make a donation, we really appreciate that. You can visit our website, lexrex.org. That's LEXREX.org.
Perfect. Well, just as a reminder, this podcast is a legal issues podcast. It is not a political issues podcast. We try to keep commentary just to legal issues. Today, as we all know, many legal issues tend to overlap with political issues, even with the court becoming so politicized that they seem like one and the same. So it's especially important for us to make that distinction today.
Yeah, that's actually Alexis de Tocqueville talked about that way back in, when was he writing? Like early 19th century. He was basically sent by France to figure out democracy doesn't seem to be working well for us in France. Figure out what they're doing in America differently. What makes it work for them? So he wrote a book, Democracy in America, where he talked about what worked and what didn't in America. And one of the things that he noted is that legal issues in America don't seem to be all that separate from political ones. But we're going to try our best to make sure that there is some distinction there, even though there's going to be some overlap. That's natural. That's not a problem. That's just the way things are. So anyway, our name Lex Rex, I didn't need to explain all that, but I did anyway. So our name Lex Rex is actually Latin for the law is king, because we believe that the law is our only king, not Charles or anybody else.
Absolutely. So
it's not true
speaking
in other places,
right? Yeah, speaking of, we, as in not us, but Britain, the United Kingdom in general, actually does have a new monarch. We went to God Save the Queen, I guess.
Yep.
That's what they say there.
The Queen is dead. Long live the King.
Well, rest in peace,
that was,
Queen Lizzie.
You know, for a third of America's total existence, Elizabeth was monarch of Britain. That is a lot. I mean, basically the entire modern world, Elizabeth presided over it. That's a huge loss.
Yeah, she really got a chance to see quite, some interesting highlights of American politics. Definitely, I think she met something like 13 out of 14 presidents somewhere along there.
That's a lot
so yeah,
of
she
presidents.
definitely had quite the survey of American history. To start today, we are going to get into some current American politics instead of Britain. We are trading in our tea for coffee. And
I still drink tea, but I guess I'm a bad American.
I drink coffee and I drink it black.
Good for you.
Like a true-blooded American.
That actually does stem to the Stamp Act, because when the British imposed taxes on tea, extra taxes on tea, which actually, by the way, did not make their tea more expensive. It made it cheaper, but it gave the East India Company an exclusive monopoly. The Americans were so mad, they stopped drinking tea altogether, and we are a coffee-drinking country to this day because of that. So, fun fact.
Yeah, it's beautiful. Really is. Rejecting things on principle is a purely American thing. And
drinking an inferior beverage just because the other one is now subject to a new tax.
And choosing to pay more for it as well.
Yep.
Distinctly American. But we'll jump ahead. And so we wanted to forecast some of the upcoming Supreme Court cases that will be coming up on the docket. They are currently on a little vacay, a little recess. And we'll take a look at 2 petitions being considered, or that have already been considered by lower
These are
courts.
petitions for writ of certiorari. I don't believe either of these have been granted yet. I believe they're currently on petition. Supreme Court's going to be considering them early in its term. I hope they'll be granting cert on both of these. And when I say certiorari, another fancy Latin word, but basically what writ of certiorari refers to is a petition to the Supreme Court saying, please hear our case. And we're hoping the Supreme Court says yes to both of those. So that's what we're looking at. We're going to give our little pitches for why these are important cases, but we hope that you guys agree.
And it's not just because we want the Supreme Court to really earn their salary. We want to make sure they're
they
working.
Get paid pretty well.
Yeah, we want to make sure that they are hearing cases and not just, sitting, taking a longer vacation.
Yeah. And the other thing is, both of these cases we're going to look at are cases that are on matters of criminal procedure. Now, we did sort of our first criminal procedure video, came out last Friday. I did that with Alex Bostic. Check that out if you get a chance. Lots of new hosts this week. But this is sort of our next foray into criminal procedure as far as our education wing is concerned, because we think it's very important. One of the areas of traditional American English rights that I think has been most eroded over the past, really it's just last couple decades, past 20 years or so, is rights of the accused. Really one of the hallmarks of the American legal system is the way in which we treat the accused, that you are innocent until proven guilty, and we have all the different markers of treating somebody as innocent until that verdict is finally handed down. I think that's gradually been struck away. And a lot of that's because the criminals that come before the Supreme Court are debatably pretty bad people. So throwing a conviction out on what appears to be a technicality is something that in most instances our justices don't really want to do. But we would encourage people to think about the fact that it's much better, how does the saying go? You'd rather let 1,000 guilty men go free than convict a single innocent person. And the way that you ensure that is good procedure. It really is important. I think it's foundational to the idea of liberty. So that's going to be one of the things that we're looking at today.
Yeah. Not every one of the exceptions where, somebody gets out on a technicality, so to speak, is going to be a Bill Cosby, where it's somebody who has committed.
Well, he did get convicted.
Well, he
the
did,
system worked
but then
he
also ended up getting his punishment, or he essentially got out on a technicality because of that.
Was it a mistrial? I don't remember all the facts on that.
I believe that they had used evidence that was given again, this may not be something to get into because we don't have the case in front of us. We have other cases to review. But essentially, he got out. Keep in mind,
the reporting on legal matters tends to be really, really bad. So part of why Eric's being hesitant to give you guys the details here is that he may not have looked at the actual papers in front of the court at the time. I know I didn't. I wasn't following that case terribly closely. But that's something to consider.
Again, not a lawyer. But let's pivot back to what we were originally looking at, which the first of the 2 cases that we are looking at as far as the broader topic of criminal justice is Shaw versus the United States. Yeah. So just to give everybody a little bit of background here, or did you want to do that?
Sure. So basically what this case looked at is the petitioner, that's the person who's asking the Supreme Court to hear the case, was the defendant in this case, so the person that was tried and convicted with crimes. The petitioner was convicted of a minor drug trafficking offense, several offenses actually. I think he had crack cocaine in his house, which if you are familiar with the president's super criminals bill, you know that crack cocaine is not treated it's treated very harshly by our justice system, much more harshly than regular cocaine, which I don't know what that says about Biden's son, but I guess judge that for yourself. But anyway, he was convicted of drug trafficking offenses relating to crack cocaine, and the prosecutor also brought a number of RICO charges against the defendant. So what's RICO? Well, RICO is the Racketeer Influenced and Corrupt Organizations Act. It's an act that was passed in 1970 basically to combat organized crime so that the government could go against the mafia in those cases, because it's very difficult to prosecute mafiosos as anything other than individuals, and prosecuting them as individuals doesn't accomplish anything. So Congress figured we need some very broad, very permissive legislation that will allow us to go after these people. Frankly, even we don't have all that much evidence against them because we know who they are, right? Wink, wink, nudge, nudge. As you can guess, Lex Rex is generally not a big fan of that sort of legislation, but what RICO is typically used for is to prosecute people who are involved in some kind of conspiracy across state lines, because remember, under Article 1 of the Constitution, Congress can't regulate it unless it's between the states. So, yeah, or conspiracy between state lines involving money. So they charge this guy with several RICO charges in addition to these drug trafficking offenses. Jury looked at that and they said, no, we don't think he's guilty of the conspiracy stuff. We don't think he's guilty under RICO, but we do think that he had crack cocaine in his house and we think he was probably selling it to people, so we're going to find him guilty of that. Judge looked at this and actually commented on the record that he thought the jury's findings were bad. He thought this guy should have been found guilty under the RICO causes of action. And well, it turns out that federal law also gives judges fairly broad latitude when it comes to sentencing. And there's a law saying that judges can ratchet up, they can increase the sentence, make it more severe, if they believe that what the person did is part of being a career criminal. So if there's evidence that person was a career criminal. So he does that. Well, what's the problem here? Well, the facts the judge relied upon to say that this guy is a career criminal are the same facts the jury had implicitly rejected by saying he was not guilty for those RICO causes of action. So that is now currently on petition for writ of certiorari to the Supreme Court. They are bringing several issues here, several legal issues, basically under the Fifth and Sixth Amendments. So the Sixth Amendment is sort of the overriding one, and it's the overriding one because it's the one that has not been heard before. But what's the Sixth Amendment say? Well, it says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by, and this is the important part, an impartial jury of the state and district wherein the crime shall have been committed. So that's the Sixth Amendment claim that's going on here. Well, how is that involved? Well, trial by jury of your peers means trial according to common law rules, which means, as we told you guys before on this podcast, that the jury is the finder of fact. The judge is the finder of law. So if you're considering whether or not something happened, you got to defer to the jury. Well, what's the problem that's going on here then? Well, it appears that the judge is deciding that something in fact happened, i.e. evidence of career criminality, based on something the jury did not find, since they found that those crimes had not been committed. So that's the basic issue. That's the overriding issue here. They're also bringing Fifth Amendment issues. Now, what's the Fifth Amendment have to say? So the Fifth Amendment says is that no person shall be held twice for the same crime. Put in jeopardy twice, put jeopardy of life and limb. That's called the Double Jeopardy Clause. And then it also says that no person shall be deprived of life, liberty, or property without due process of the law. So several clauses in that amendment. Those are the two relevant ones. Well, how does double jeopardy apply here? Well, essentially what they're arguing is that this guy is being forced to be tried twice for the same offense because the jury already looked at these facts, said they weren't met. Now the judge is looking at the same facts again. I think that's probably not a strong claim for reasons that we can get into in a bit. But there's precedent on that. Also, it's just in point of fact not the same crime. They may depend on the same facts, but I think that is one of the weaker of the claims brought here. And then also the Due Process Clause of the Fifth Amendment, that no one shall be deprived of life, liberty, or property without the due process of the law. Now, what's the argument here? Well, basically, it's the same as the Sixth Amendment argument, that having a jury be the fact finder in a case is part of the due process of the law, because that's the process that's required. So those are the issues the court's currently looking at. Court has heard some of these issues before. Eric, I'm kind of going on and on here. You got anything to jump in and say? Or?
No, not as far as from an analytical perspective. I'm much more of a legal novice when it comes to the interpretations of these sorts of things.
Well, what's your knee jerk here? How does that sound to you?
Well, it seems like, and again, I'm not sure if this is actually from a legal way of thinking about things.
We get, so
it's certainly
for the audience and for Eric. Eric knows this, but the audience might not know this. We intentionally don't have two lawyers on this podcast because that would be really, really boring. None of it would be approachable. And we want to make sure that it's not just dry analytical, which is what lawyers would do. So that's why you're here, Eric.
Fair. It certainly sounds like, well, it sounds like in a case where you'll you see this all the time on TV law, where you'll have something that's presented as evidence. It's for some reason is not relevant, so it gets stricken from the record, right? And they instruct the jury, hey, the judge goes, don't listen to any of that. Just pretend it never happened.
And then they do the thing where they say,
make your judgment.
Objection, sustained. And then it's all about the jury heard it anyway.
Yeah.
It's...
Yes. What do you do?
Yeah.
But it certainly seems like something like that, right? Like the judge was making a decision based on something that the jury in this case had excluded and said, well, we don't find him guilty of that. And then he kind of just took a little bit of that and put it in his judgment pot anyway.
Yeah, it's almost like the opposite of that, isn't it? Because usually it's a judge telling a jury not to consider something. Here, the judge is supposed to be precluded from considering something, but he's a judge. He's the big boss man. He's going to consider what he wants to consider. And if he wants to say the jury was a bad jury, made a bad decision, well, he's going to do that. And that's what he did here. That's a good point. I actually would never have looked at it that way, but that is essentially sort of what's going on. And that issue...
Maybe I am a lawyer.
Yeah, maybe. But, so what I would also add, though, is I do want to keep the Sixth Amendment and Fifth Amendment claims separate here. The Fifth Amendment issue has actually previously been considered by the court. That was considered in a 1997 case, a fairly famous case. It's called U.S. v. Watts. And part of the petition in the case we're currently talking about, in Shaw v. U.S., is they say, if you can't rule in favor of us on Sixth Amendment grounds, you got to overturn U.S. v. Watts. Because what does U.S. v. Watts say? Well, that one was a very similar case, except in that one, it involved basically a crime that said if you use a firearm in connection with a drug offense, then you're guilty of a crime. That's its own crime, separate from the rest of it. Well, what happened was the police came into this guy's house. They found that he had cocaine. This was regular cocaine, not crack cocaine. So I guess they don't treat that as strictly for whatever reason. But he had cocaine on his person. He also had 2 loaded firearms that were in his house, I guess found separately from the cocaine. So they added that. They said, I guess having them loaded constitutes using them in the mind of some prosecutors. So they added that as a separate charge, and the jury found him not guilty on that charge. They only found him guilty on the possession distribution charges. What the court considered in that case was just the Fifth Amendment double jeopardy issue. And that's part of why I say I think the double jeopardy issue was the weaker claim here, because they said, no, that doesn't count as being tried twice. Judges are well within their rights to consider evidence outside of what constituted whatever offenses the jury is finding the person guilty for, as long as that evidence was presented at trial and appears to be credible. That might not be a great ruling. I don't think it's a great ruling. I don't think it's a horrendous ruling either. I really don't think judges ought to be finding fact. I think that's a matter for a jury to consider, because a judge is no better than anybody else at knowing what's true and false. The judges are better at the law, which is why we give them questions of law. So I take that as you will. That is what it is. But the problem with this case is that a lot of lower courts have taken that reasoning and they've applied it to Sixth Amendment claims too. So they've applied it not just where there's double jeopardy issues, but they've also said when these Sixth Amendment claims apply. So if you recall, Sixth Amendment claim here was the jury clause. The right to a trial by jury, where a jury is the fact finder in your case. And what judges have been doing is they've been applying this Fifth Amendment rationale, this double jeopardy rationale, to cases about whether or not the jury considered everything they were supposed to consider, whether or not your judge is in fact acting as your jury instead. That's not the appropriate context to apply that. So that reasoning about a judge can, in some circumstances, sentence... Well, let's take a step back here. Eric, how would you intuitively assume that sentencing works? If you know that a judge has a range of, he can give a guy 5 years for this crime, but it can ratchet all the way up to 20 years, how would you assume a judge makes that decision?
He's got like a guidebook for crimes based on the laws, right? So essentially, if, say, the jury, say, convicts him of X crime, judge takes a look in his little book and says, X crime, that's punishable from 5 to 10 years. Based on what we had all heard today, I'd say this was a really bad one, so we're going to give him the max, 10 years.
When it's a really bad one, they go with a higher sentence, right? So just a simple example of that. So you got an assault case. If somebody assaults somebody else and you heard that it was because, I don't know, they slept with their wife or something, judge might be a little bit more understanding than if he assaulted somebody because he was of a race that person didn't like, right? I mean, one is a pretty understandable reason for assaulting somebody. One is one that we don't find all that understandable. We would probably be less lenient on the second one. That, of necessity, requires judges to consider facts that were non-dispositive in the jury's verdict, because those facts have nothing to do with whether or not the person is guilty. So dispositive means that it makes or breaks the case. You know, it's enough on its own to decide the case. In other words, the dispositive facts are the ones that, because they are true, the guy is guilty. If this were not true, the guy would not be guilty. Those are the dispositive.
Essentially, the videotape of him assaulting the person.
Yeah.
Right.
That's
evidence.
Yeah, we saw him do it. We saw him assault somebody. That's the dispositive fact in this case. Judges have to consider non-dispositive facts whenever they're passing any kind of a sentence, because that's what allows you to say this was a more severe instance of this as opposed to a less severe one. Because the jury just comes back and tells you, we think this guy is guilty, as opposed to we think this guy is not guilty. They don't tell you how bad they thought it was. Judge has to decide that on his own. So what the court said in that Watts case in 1997, to get us way back to long walk for a short drink of water, what they said in that case was that, yeah, judges can absolutely consider stuff like this. That's not double jeopardy for a judge to do that. Because in that case, you know, the fact that there were weapons involved, that there were loaded weapons in the house, that made it more severe than if those weapons weren't there, whether or not those weapons were actually used in connection with the crime. I think it's utterly absurd to say they were used in connection with the crime. I do think it makes sense to say this guy was probably a little bit more dangerous of a criminal because he had loaded weapons in his house than if he didn't. Now, yeah, I know probably half of you are recoiling right now because that offends your Second Amendment sensibilities. Kind of offends mine too, to be completely honest with you. But I can at least understand why, like, the threat to police officers would be greater when investigating him. Sure, that's within judicial discretion. He can ratchet it up a little bit higher. I can at least understand the reasoning there, whether or not I agree with that. Fair enough, Eric?
Yeah, we'll go with on this one. But
I'm not saying I would find the same way as a judge. I'm saying that I think that's validly within judicial discretion to decide that way. The issue in Shaw is quite different from that, because the issue in Shaw is ratcheting up somebody's sentence on the basis of finding that person is a career criminal. It's not just facts and circumstances of the crime that was committed. It's well beyond that. Because career criminality means there's evidence of more than one crime, right? So in other words, something that you could at least conceivably charge a person with, prosecute them with, and convict them of. That's not what's went on here. I think also doubly troubling is the fact that the judge explicitly said he did not agree with the jury's finding on those RICO charges. I think this case really ought to be a slam dunk in favor of the petitioners. I think it is sufficiently different from Watts that I don't think a reasonable court could decide against the petitioner here.
And it makes sense not to bring in things outside of what the person is charged for, or is like not just charged, but the sentencing that's given. It makes sense not to bring in things that are outside of that judgment by a judge who feels differently than a jury. Essentially, that's where you have kind of, you have runaway judges. You have it's no longer linked to the jury of your peers. It is something where one person essentially sees themselves above the peers that are making that decision, and they're going ahead and saying, I know best.
And that's exactly what's troubling to me there as well. Yeah. And I absolutely do think, whether or not it violates double jeopardy clause, whether or not he's being put under jeopardy of life and limb twice, whether or not it's due process of the law, although I think it probably does violate his due process rights, but irrespective of all of that, it's certainly, in my view, depriving him of his right to a trial by jury of his peers. Because they explicitly said, no, we do not think he is guilty of criminal conspiracy. And then the judge is saying, I'm going to sentence you as a career criminal based on those conspiracy allegations. I don't think that's at all appropriate. And I think that there ever since that 1997 case, that Watts case that I mentioned, there's been so much judicial discretion on this kind of stuff. Judges feel fine to say, we're going to conclude based on the evidence presented at trial, totally irrespective of what the jury found. That was not what Watts said. All that Watts said was that you can consider the severity of the circumstances of the crime when passing sentence. This goes way beyond that. Judges frequently, regularly even go way beyond that. Court needs to rein that in. So I welcome court granting cert on that. Lex Rex will probably write an amicus brief on that in support of petitioners, because I think that's a pretty important issue. We don't want to erode our Sixth Amendment rights.
Absolutely agreed. So keep an eye on that Supreme Court docket as it comes up. Some exciting things coming around. The next one is Ruiz v. Massachusetts.
We probably should have started with this one, because this one's a little bit simpler. it's
Sorry,
part of the reason why judges
You've already
and
had
juries,
the hearty dinner.
right? Part of the reason why judges and juries consider separate issues is because the intersection of the things would be way too complicated for a jury to consider all of it.
Luckily, after this podcast, you can actually take the bar exam and pass in California. So,
if you want to put in a whole heck of a lot of work, go to 3 years of law school.
There you go. Get you charged up on it. So
I don't
let's
recommend
go
it unless you're really sure you want to be a lawyer.
Yeah, it's not exactly one of those hobbyist activities as becoming a lawyer.
No.
So let's go ahead and jump into some of the background of Ruiz v. Massachusetts.
So here it's basically what happened is petitioner was tried along with a co-defendant. Both people were involved in the same crime. Facts were essentially the same for both of these defendants. I don't even remember what the crime was. It doesn't really matter for what's going on in this case. But basically what happened is neither of these co-defendants testified at trial. You hear testimony of different witnesses. Oftentimes the accused will themselves want to testify. They don't have to do that because of a little thing, again, called the Fifth Amendment. This time, the clause against self-incrimination, that nobody will be compelled to be a witness against himself. So kind of classic example of being a witness against yourself is actually appearing in trial to testify. That's what you think of when you think of a witness, right? So if you are a criminal defendant, nobody can compel you to testify against yourself. That's what's going on here. Neither of them did that. Kind of sidebar here. It's generally a really bad idea to testify in your own criminal trial. Nearly every criminal defense attorney will advise their client not to testify in their own criminal trial because it's only going to hurt you. Whenever you watch those high-profile trials where they always have the criminal defendant testifying, that's because the defendant asked their lawyer to do that. A lawyer is actually legally prohibited from taking steps to make sure his client doesn't testify. So generally, just keep in mind that's almost always done against advice of counsel. So, yeah.
Don't do it. Don't,
we can't give legal advice, Eric, but in general, that is not advisable. So
you're giving them the rope to hang you with.
Yeah.
99% of the time.
Yeah, so. Generally, you don't want to do that. So these guys were smart. They didn't do it. But that didn't save them either. Because what ended up happening? Well, the jury was watching them through the whole trial. As juries do. You can't help that as a juror. You're going to look at the defendant's expression when people are testifying, and you'd be like, oh, gee, wow, that was some really bad facts that witness just gave. I wonder what that guy's reaction to that is. You're going to look over and you're going to see how he reacts. And I guess based on this defendant's body language, the jury thought he was probably guilty. So, which, again, off the record here, I'm sure that happens in trials every day. I'm sure every day jurors don't really have enough evidence to convict if they purely look at the evidentiary record. But based on their feelings about somebody, they say, nah, I really think the guy did it, and they rule a certain way. I'm sure that happens every single day. Problem is, in this particular case, the jury asked the judge if they could do that. What did the judge say, Eric?
So the judge replied, under Massachusetts law, that they could not consider the defendant's demeanor as evidence, but they could consider any observations made during the trial.
Yeah. So Massachusetts law says you can consider
evidence?
any observations made during trial. Now, what's the issue here? The issue is there's always a record of evidence in trials, right? So there's a court reporter. Every trial has a court reporter. It's actually, of all the government people, of all the government employees who are in the room during a trial, the court reporter is the best paid of any of those people.
Correct me if I'm wrong as well. When the court reporter is taking down notes, they're not writing like a screenwriter would write.
Suspiciously.
Defendant makes incredulous look.
Yeah.
Defendant scoffs.
As if very, very guilty, defendant says. Yeah. Yeah. No, they try not to do that. In fact, they never do that in any transcript that I've ever seen. But yeah, the best paid government person in that room, other than the judge, they're obviously paid a little better. But a bailiff, all the different people in the room, court reporters are very well paid. So because it's very, very important to get an accurate record. That's what's used on appeal. And juries are supposed to rule on the basis of the record, right? That's the evidence that's in front of you, is the evidentiary record. So when you consider things like body language, physical demeanor, other non-verbal things presented at trial, those things didn't make it onto the record. So you are technically issuing a verdict against what's on the record. Now, we all know that probably happens every day, but part of an impartial jury is at least trying not to do that, right? Trying to rule based on the evidence that's presented to you. We know that's hard to do. We know humans are fallible. We know that emotions are involved in every decision we make, but we try to minimize that in court. We know it's not going to be perfect, but we get the closest we can. So the question is, was this a bad jury instruction when the judge said that he could consider any observations made during the trial? What do you think, Eric? What's your knee-jerk on that? I'm curious.
I mean, so there's two ways, I think, when I read this or when I see what kind of was instructed, because observations can go like one of two ways. You can have like observations that are made and like
of physical evidence, right? Like, here's the murder weapon.
Yeah, exactly.
There was blood on it.
But to say, like, especially if it makes it onto the record, right? Like, I would think that would be like, you know, what maybe the judge was saying, and then it was interpreted poorly. But also, if you're saying something of, you can't consider the defendant's demeanor as evidence, but you can consider any observations made. It's kind of vague whether the jury is the one making those observations, or if those observations made are in evidence, if like a witness were saying something about the body language of somebody in like of the defendant, if that makes sense, right? If a witness is previously recounting what the body language was, like, hey, he was sweating, and when I was the police officer saying, hey, he was sweating when I was questioning him about this, and I thought that it seemed like he was hiding something, right? That's an observation of body language, but it is not the observation of body language in the court at the time of doing that, which is what the jury made their decision based on, which is why they convicted one and not the other. Yeah,
that's because if the facts were pretty much exactly the same for both defendants and they convicted one of them, what can the ruling possibly be based on? Or rather, what can the verdict possibly be based on?
I didn't like the look of that guy.
Yeah, it's pretty much just his body language.
Stink. Being the guy that got convicted. Like, what about him? Me, but not... Just because you had a guilty look. I didn't like you, so you're guilty.
Yeah, so here's, I want to give the actual language because it's a little bit confusing if you read the petition here, what was going on. Because they make the claim that the judge invited the jury to consider his body language. Technically, he didn't do that, but here we've got, so the exact questions asked by the jury here were, can we take the defendant's body language into consideration as evidence? And then over the petitioner's repeated objections, but in compliance with settled Massachusetts law on the topic, the judge answered this way. He said, while not in evidence, the jury is entitled to consider any observations you made of the defendant's demeanor during the trial. That does not sound to me like the judge is rejecting the ability of the jury to decide based on body language at all. I would probably read that as an invitation to do so as well.
It's kind of a case of the files are in the computer. You know?
You kind of have to already know the defined terms here to not think that way, right?
It definitely seems that way, because if I were just reading this as a layperson, as I am, it definitely seems like they're saying, hey, look at him during the trial. If he looks like he's guilty, then make your decision that way.
Yeah.
But I'm sure when the judge was presenting that information, that he was coming from the mindset of saying, observations like we had said previously.
Well, and what does that even mean? Because it's, while not evidence, the jury is entitled to consider.
Oh.
Well, but the jury is supposed to rule based on evidence. So for what purpose are they considering those things? If they find somebody guilty, they have to find them guilty based on evidence. Yet they're told that they can consider this thing that they are told is not evidence. What are they supposed to do with that?
I recant what I had said previously. It just sounds like a bad instruction.
I think it's a bad instruction. Actually, I think it may be a fine instruction consistent with Massachusetts law. But sort of my broader point I wanted to make about this one is this is a strange eccentricity of Massachusetts law. Other states don't have this. I think it's very clear that a judge should instruct a jury only to consider evidence. Now, you could say the way in which they said something, but and why is that? Sort of we started this whole conversation saying that there's a Fifth Amendment right against self-incrimination. Both of these guys exercise that right. Yet they're still essentially being forced to be witnesses against themselves, aren't they? Because even though they didn't take the stand, people are still staring at them, and they're still saying whether or not they appear to be guilty or innocent based on their demeanor. That, to me, sounds like being forced to be a witness against yourself, no?
That is fair. I do think, like, isn't there the court can consider things, or at least when you're questioned by police officers, they can consider things like your body language and demeanor.
So the way that
things like that,
the way that would enter the evidentiary record is you'd have a police officer testifying at trial, and the lawyer would ask, did the defendant appear to be agitated when you questioned him? And the police officer would say yes. And then the lawyer would say, in your estimation, did he appear to be telling the truth? And the police officer would say, no, he did not appear to be telling the truth. Now it's on the record that based on his physical demeanor, the fact that he seemed agitated, he's more likely to be guilty.
Fair point about the record. So, I mean, when say this is through the process of the cert, the writ of certiorari, when this gets elevated to a higher court to be reviewed, they are going to look at the record.
Right.
They're going to see, hey, none of this body language, demeanor stuff was actually recorded.
Well, and part of it too
seems,
because if a jury's looking at a witness and judging the witness's physical demeanor or their body language, that makes a little more sense to me, because juries are fact finders. That's part of what you're doing. You have to judge who's telling the truth in this case versus who's not telling the truth, and there's not always facts that can show you whether or not that's who that's true of. You can't always judge that factually. You have to do it based on your gut. You have to do it based on who you trust. That guy appeared to be more reliable. He didn't look at his feet the whole time, whatever it is. And that's the reason why appellate courts almost always defer to factual findings of lower courts, because we want juries to be the ones to make that determination. Juries are the best finders of fact that we have. The issue here is that when someone didn't testify because they have a Fifth Amendment right against self-incrimination, that we are still trying to judge that person's truth or lack thereof based on their physical demeanor. Well, they didn't say anything. There's no truth or lack thereof to judge, which that would be my issue with this. It's in considering a witness's testimony makes complete sense, because that's what you're supposed to be judging. That's what's been put in front of you to judge. When considering somebody that has not been put in front of you, it's not currently testifying as a witness, there's nothing that you're being asked to judge there. You're looking at something fairly extraneous.
And I don't know if I'm using this term right, but when like the material evidence is all the same for two people, one gets convicted, one doesn't, that seems like injustice as could be most clearly illustrated.
Yeah.
Right? Either one of them, either they're both guilty or they're both not, if everything is the same between them.
Well, yeah, and if that's weighed as evidence, if that's something that ends up being dispositive in this case, which that's when it's the thing that makes the difference between two equally situated defendants, that is absolutely a dispositive thing. If that's what ends up being dispositive, well, then isn't the guy sort of being compelled to witness against himself, because he has to sit there through the whole trial? He doesn't have the option to not show up for his trial. He can't be tried in absentia. We have laws against that. So wouldn't we sort of be saying that by showing up to your trial at all, well, we can't put you on the stand, but we are going to make you a witness against yourself because the jury can still weigh it as evidence?
That definitely makes sense. I think
I've strung you along here.
It's tough to say, right? Yeah. No, I mean, I think it makes sense, right? Because in a way, you're questioning them without questioning them.
Yeah.
Right. You're getting their reaction, but it's also not in a way that. And I think that this is kind of the.
Well, it ended up being the most important evidence in the case. Sorry to interrupt you, Eric.
Yeah, when it's the defining reason for somebody to be convicted and another not.
You were going to say something. I'm sorry.
Oh, it's just that when, so say it does, basically get popped up to a higher court to get reviewed, they're not going to have the actual defining bit of evidence, a rejected red stamp just is going to come on it. But that's kind of the fun thing about these these issues with the courts, is that you kind of never know.
Yeah. Well, and it's, we believe, or at least I believe, don't want to speak for everybody at Lex Rex, but I believe that Fifth Amendment rights ought to be very strongly protected, especially the right against self-incrimination, because it's so abused, really, by police departments throughout this country. That's not police officers' fault. That's not a criticism of police officers themselves. They're trained by a lot of the best paid lawyers in the country to come around and say exactly what they can do to extract a confession and what they can't do to extract a confession. So they'll toe right up to whatever line you set. You can guarantee, if you get a bad ruling on this case, if the court does grant cert and then rules against the defendant here, you can guarantee the training for lawyers is going to change after this. It's going to be you draw as much attention as possible to non-testifying defendants. You say, look how he looked at his hands the whole trial. And if he didn't look at his hands, you say, look how he confidently stared ahead as if in defiance of this jury. We really don't want the dispositive issues in cases to become entirely about the way that defendants acted when not on the stand. That's not great.
Because really, I mean, that it just takes a good spin artist, right? You could just be, like you said, you can literally paint. If everything that somebody is doing is a potential evidentiary reason for them to be guilty, then there's nothing that they can't do.
Yeah.
Look at them staring confidently. Look at them acting guilty by making, such a blubbering mess of themselves. Really, there's nothing that they could. Everything. I mean,
I'd probably instruct clients to wear a bag over their head to court.
Yeah. Right.
And then I would say, like, I put it on the record under advice of counsel, he's wearing a bag over his head because I don't know what you guys are going to consider, and I believe strongly in his right against self-incrimination. So I'm not going to have him sit here and incriminate himself.
Yeah, let's hope the court side's on the right side of that case, because that is definitely something which should raise an eyebrow if it goes any which way but rejected.
Yeah. Well, I want them to grant cert. And then I want them to rule in favor of the petitioner. So the language on this stuff gets weird because it's double negatives and whatnot. But yeah.
Yeah, exactly. All right, perfect. Well, those are some fun cases coming up on the possibly coming up on the Supreme Court's docket. Shaw v. United States and Ruiz v. Massachusetts. So with that, we're going to cut this segment short and move on to Captain Kangaroo Court. Yeah. Play that theme music.
Let me find it. All right, folks, welcome everybody. Come around, young and old, boys and girls, ladies and gentlemen. It's time for everyone's favorite section of this podcast, Captain Kangaroo Court. There, I hit the mark that time.
All right.
Yeah, that's Captain Kangaroo Court.
Sad to hear it go, because it's such a pleasant little ditty.
Yeah, well, we'll hear it again at the end. Don't worry, David. Or David. I'm too used to this. Don't worry, Eric. You'll hear it again soon enough.
Look at me. I am the David now.
Yeah, he's David now. David, I hope you're listening to this because you've been replaced.
You've been supplanted. Line of succession states.
Yeah, does Eric have a valid claim to the podcast?
We will see. We'll leave it to the lawyers.
This is a point worth noting. So everybody talks about elections like they're such a big deal. Tons of monarchies in Britain, not in Britain, actually, yeah, in Britain too, even prior to William the Conqueror at least, but throughout most of Europe, most monarchies were elective. The thing was nobody ever voted for someone that wasn't the king's firstborn son, because that's the only person that everybody could agree on. That's why we were so unsure that elections would work in the United States, and really ended up happening to be blessed by the fact that George Washington had no sons, and the fact that he, retired from political life. But anyway, that's sort of fun fact. Elections tend not to be something that's actually you vote for whoever the heck you want. It's just sort of putting a rubber stamp on who the next guy is going to be. It's America that changed that. So that's not so much a kangaroo court thing, just a fun fact. But all right. So what have you got for us today, Eric?
The more you know. All right. Perfect. Well, we're going to start off today with, let me get this on over to you. So we're looking at an article from Business Insider, renowned constitutional scholar, Business Insider, with an article entitled...
They're one of the best of them. We had our conference in Washington, D.C. with all the constitutional lawyers, and Business Insider, they were right at the top.
And with that, this article is entitled... in case the sarcasm wasn't dripping enough for you. So the article is entitled, Republicans Want to Rewrite the Constitution to Limit Federal Power, but a former senator says a runaway convention could spell danger for healthcare, education, and the environment.
Oh, that's the risk, is it? Not that we could potentially lose our Constitution. It's the risk is that it might be bad for the environment.
Not that laws you previously held dear and things like double jeopardy or quartering of soldiers and all those other fun ones could just go out the door. Free speech.
Having a president. Having states.
No, not that all of the organization and all the thought that was written into the Constitution could go out the door for whatever people decide at this constitutional convention. No, that it could spell disaster. So essentially, some of the points of this article,
I guess that's the fear because Republicans are holding it, right? Because if it were Democrats, we'd say that it would do a whole host of other things the Republicans don't like. But.
Exactly. I mean, you can't really get something. And again, I'm probably, well, actually, this is probably new information for everybody. I'm probably one of the more left-leaning, or more further left-leaning than what might be the median political belief behind the Lex Rex Institute. And
we love you for that, Eric. No, really, because we are not a partisan organization. Anybody who wants to uphold the Constitution is welcome here.
Yeah, actually, and part of the reason actually why I joined and put so much effort into the Lex Rex Institute is because I'd previously volunteered with the ACLU, and a lot of that was based on their championed cause of forwarding civil liberties in the United States. They had gotten a little too political for my tastes.
They go back and forth. They've been hit and miss over the years. They'll probably find their way again.
Yeah, hopefully. So I still, keep in touch with my contacts there. But
my favorite one was when they defended the rights of students to protest the ACLU. They took that case. That to me is the most principled case that anyone's taken in the past 50 years. So
yeah, that's literally the Patrick Henry quote?
Give me liberty or give me death. The Voltaire, I may not agree with a word you say, but I will defend your death, the right to say it.
That's the one.
Okay.
Yes. That reminds me of the Voltaire quote. All right.
It could have been Patrick Henry. I'm sure he would agree with that.
Yeah, that's fair. I have a knack for attributing apocryphal quotes. So Article 5, Constitutional Convention. This writer of this book peddler is spelling a little bit of danger on the horizon from Republicans coming and doing a constitutional convention to...
because what happened...
And I say this with seriousness, limit the power of the federal government.
Well, that's what they say they're going to do. But what happened the last time we had a constitutional convention, Eric?
It's actually a great question because there hasn't.
We got the Constitution.
Except for the original one, yeah.
Yeah, we got the Constitution. That's the last time we had one of these. Other than that, every amendment's been passed via the Article 6 route, which is basically consensus among the states. For you send it to state legislatures, and the state legislatures have to vote to ratify that amendment. Then it becomes an amendment. Sort of a much more public process. Convention, states just appoint delegates to a convention. They go and figure it out, and they send it back. And then you got a new constitution. Now, our founding fathers, because they were so worried about the appearance of that kind of convention, they said, our suggestions, the amendment, the constitution we proposed, that's not going to become a constitution until the states have ratified it. And it goes to state ratifying conventions to do that. Under the Article 5 procedure, we don't have that step. It's just whatever this convention decides to do. So they can get together, they can say, hey, I don't think limiting the power of the federal government is a great idea, actually. In fact, I think that it should have unlimited powers and that I should be the one in charge of it. A lot of people are tempted to that.
Wyoming became the federal government.
Yeah, right.
Yeah, I don't think you're going to get a lot of states agreeing in that way. There is an interesting quote, or at least, they say the framers left no rules. In this uncertainty lies great danger and possibly great power.
I tend to agree with that.
And with great power comes great responsibility.
Yeah, I tend to think that Article 6 is the better route. It's the more public one. I think that Article 5 is really there in the event the Constitution turns out to not work as well as they anticipated. But, it's been going 250 years strong at this point. I think it's working fairly well. The Article 5 route is proposed by a lot of people because it's perceived to be quicker and easier, much like the dark side of the Force.
It seems like it's one of those things that gets touted like packing the court sort of thing as like the red button, the kind of nuke it situation.
Well, they could.
Where the realistic possibility of it happening is pretty low.
Yeah.
Right.
Yep.
And on top of it, I mean, there is some interesting things. I don't think that we'd, like, from a personal opinion, I don't think that we would see that happen. I don't think that we would see a lot of the states agree on a lot of certain things, because those delegates that are coming, the assumption is that they're appointed by the state legislatures. and then they would go together and then, formally make decisions. I guess would that just be, and that would be just basically they could go in and just, either nullify amendments or ratify new ones.
Or nullify anything that's in the Constitution, really, and then do whatever they want, which is kind of the fear here. Now, I think that they would have to get people from different states to agree. So there's always people a lot of the groups that oppose Article 5 conventions, and I do oppose Article 5 conventions pretty strongly because I think it's too risky, no reason to do it that way. But a lot of the groups that oppose this tend to have a little bit of a conspiratorial bent to them. Because what they think is, well, this one group, this one powerful kind of secret group is going to make sure that a bunch of states appoint their people as delegates to this thing. And because they're not necessarily public figures that are going to this thing, people will not know that ahead of time. There is a real risk of that. I don't know that that's what's going on currently. Actually, we're working on a case that we haven't made public yet that shows that maybe exactly what's going on. I don't know how much power the group behind it has, but it does appear that they're at least trying to do that. But yeah, anyway, the opposition does tend to take on a little bit of a conspiratorial bent, and you can see that language reflected in this article for sure.
Well, I may not be a lawyer as a hobbyist, but I am a conspiracy theorist as a hobbyist. So that really...
well, you'll have to read our article
really
about it when we're done on the case that we're working on. It's a lot of follow the money kind of stuff. So, this group got money to wash it so that you couldn't see what they were doing with it, that sort of thing.
Yeah, interesting. In the words of a comedian whose clip has been circulating around various social media, if you don't believe in conspiracy theorists, what, you think the federal government's just batting 1,000?
Yeah. Well,
you think they're just always telling the truth?
You think about conspiracy, it's actually very plausible. Because what is a conspiracy? Well, it's two or more people working together in private toward an illicit end. That's the legal definition of conspiracy. Very, very hard to prove in court because they're doing it in private and they don't keep records. But yeah, I mean, if you think that that more than one person is not working together or are not working together in Washington towards some of these ends, you're wrong. More than one person's involved in most of this stuff. So.
Well, there you go. I believe, Alex, you had our next.
Yeah, mine's really silly. I'm not sure we even want to do it. Let me pull it up, though. It's really, just as a warning, it's very, very silly. So this is a Reddit thing. We're not using Twitter this week. And what it says is, what's the worst plot hole you've seen in a well-regarded movie? And I almost said Twitter. The Reddit user, that just means user, Rob5i, I'll get this right one of these days, trust me, says, in the film Gravity, George Clooney is hanging onto a tether and insists Sandra Bullock cut him loose to save herself. This is complete nonsense, as there is no physical force pulling him away. With a slight tug on the tether, he would have floated over to her. It's a monumental plot hole. The director got an Oscar when he should have been imprisoned. So this is sort of my legal hot take, because I just wanted to point out that it's not actually illegal to make movies with glaring plot holes. Whether or not it should be, I think it's a separate issue. But I don't think he should actually be imprisoned for that. But maybe they ought to make a law against glaring plot holes.
That's a fair point. We've drifted from the laws of the American system to the laws of physics. How they're disregarded.
Yeah, that's a good point, too. They're both laws, but you don't get imprisoned for breaking both of them.
That's fair.
If you break the laws of physics, you just can't do that. But
yeah, that's fair. Perfect. Well, we will end Captain Kangaroo Court with a, I guess this is less silly and more, I want to say absurd, but we'll get your take on that.
Yeah, I have not listened to this yet.
Open here.
I just made sure the file.
Yeah, no. So just give a little bit of background on this. In Q, with my comment earlier about being slightly conspiratorial, or at least a hobbyist. This was taken from a podcast called The Tim Dillon Show. He's a comedian. He does do some political guests and have some political jokes and stuff. And then he also does some conspiratorial stuff. He brought on
sounds sort of like the Joe Rogan podcast.
Yeah, actually he was. That's where he got kind of his big break, was on the Joe Rogan.
Okay.
So that's where he.
Yeah, that's a popular format. Maybe we ought to start doing that.
Yeah, Joe, if you're listening, please have us, or at least our legal expert and president, Alex Haberbush, on. I'm sure that would be, you guys could get into some interesting things, though I doubt that Haberbush will be indulging in some of the substances that are frequented on the show.
Probably not. That's that might cause problems with my federal bar membership, because technically marijuana is still illegal nationally. So
yeah, I don't even think it's legal in Texas, but I could be wrong there.
I'm sure maybe lawyers do it on his show. I don't know, but that's you're engaged. That's some risky stuff to be doing, because currently the actual law is that marijuana is federally illegal. Just so you guys are aware. That's
fair point. Yeah, that hasn't been of all the things that we've seen happen in this administration, the thing of legalizing marijuana was not one of them.
And that's the case that said that marijuana that the federal government could even outlaw marijuana, because remember, Commerce Clause, Congress can pretty much only regulate stuff that's commerce between the states. That was a Scalia opinion when he said that it did constitute interstate commerce.
Interesting.
Apparently, he feels more strongly about drugs than he does about the Commerce Clause.
Well, we nobody nobody's nerfect,
because it's not just sale of marijuana that's illegal; it's possession and use. Yeah, I don't think there's any commerce involved there, but that's a Scalia opinion, believe it or not.
Usage. Yeah. Well, so this is taken from a podcast clip of the Tim Dillon Show. He was interviewing a Substack author who is, I guess, has a decent following. He apparently gets under a lot of people's skin, and I can see why. His name is Curtis Yarvin. He is a neo-monarchist, as Wikipedia paints him as.
We're really going to end on this, Eric?
Oh, I like to bring in a little bit of a twist to things.
I am so not a fan of monarchists. I mean, really, our name was no indication of that, right?
Yeah, and sorry, Queen Lizzie. This podcast
it's fine
episode.
For Britain, but we're not Britain, so
yeah. All right, we're gonna go ahead.
I don't oppose it on principle. I just don't understand why, if you have a Republican form of government that's working, why would you want to get rid of it? But
yeah, I don't know. This guy has some interesting takes, but he does make a to set up this clip, he's basically talking about how somebody would come in and essentially oust the political regime currently and the structure, and how they would implement something new. I think he's talking in a hypothetical of how you could get essentially,
hopefully, because if he's not, then it's sedition. So,
but essentially what he's saying, as you'll see, is that the steps that he is proclaiming are in fact constitutional.
Oh, then it's not sedition. It's just a bad idea.
So let's listen in.
All right.
The next Caesar will somehow come out of, the next president who's an FDR, who's a Kennedy, will somehow come out of an American election. That's the only way you get to be president.
Right.
Right. And they will just be like, you know what? I just got elected president. It says in the Constitution. I just read I read it. I read it on the bathroom. I read it a couple times. So I read it over again. It says that the president is a chief executive of the executive branch. To my mind, that's pretty clear. It says the Supreme Court can write opinions and Congress can pass laws. And it is the president's, understanding that he's here to execute the supreme law of the land. I, as president, will treat the opinions and the laws passed by Congress with as much respect as they deserve. There's a great deal of expertise there.
Right.
I'll listen with great interest. I am now.
So what happens?
I'm now sending the Secret Service to the Fed. They're taking over the Fed. We're going to fund an entirely new government directly from the Fed, and the power of the purse, which is.
And is that constitutional?
Yes, it's completely constitutional.
Right.
In fact, you would describe this new monarchical presidency as a constitutional presidency.
And then,
it's actually a restoration of the real Constitution to put the chief executive in charge of the executive.
So I cut it off before it gets a little wobbly there.
The Fed's not even an instrument of government. The Fed is a private bank.
So step one in his plan is
become president.
Not constitutional.
Well, step one is become president. That's fairly.
Well, he's saying this nameless president, this person who would go about this way.
Yeah. So the Federal Reserve, for those who don't know, was established in 1913, part of the Federal Reserve Act, as a private bank that could essentially issue credit in the form of purchasing treasury bonds. I'm not going to get into the economics of all that. I've got pretty strong economic opinions. Ask me about those opinions outside this podcast. I will be happy to talk to you for hours about that, as Eric knows. So, but the Federal Reserve is not an instrument of the government. If you use the Federal Reserve to fund a government that is parallel with the one authorized by the Constitution, that is the one that's enacted by Congress and subject to the president, basically executing what Congress has enacted. I'm not sure how you can square that with the idea of faithfully executing the laws of the United States and upholding the Constitution of the United States. That seems like more than a reach to me. That to me seems like treason.
Yeah, it definitely seems, and yeah, no, just from a procedural standpoint, because one of the aspects of our Constitution is not that it's just a list of rules of what people can do, and well, especially it's not just a list of what the government cannot do. It is also a procedure, or it factors in multiple levels of procedures of how things are done, right? And one of those things is that the president actually doesn't get to decide what's paid for and what's not. All of those decisions have to come from Congress.
And that's true as well. That's a separate point, really, I think, because the main mistake this guy makes is the Federal Reserve is not part of government. But say that he proposed the same plan using the Treasury, saying that we're just going to fund whatever we want using the federal Treasury. Well, the problem there is the president does not have the power of the purse. House of Representatives, of course, has the power of the purse. If you have a spending bill, it's got to originate in the House of Representatives. And the president, there actually is Supreme Court ruling on this. Supreme Court has ruled on this in the past. The president must spend money as Congress allocates it. He can't spend money in excess of what Congress allocates. He actually can't even spend less than what Congress allocates. He has to give it to whatever project Congress gives it to. So even if he were using an arm of the government to do this, what this guy is proposing is still blatantly unconstitutional. But I want to point out, using a private bank to do it, you actually don't even need the first step of this plan. You don't need to be president. If you've got a very, very powerful private bank that will give you unlimited funds, have at it. Try and have your own government. You're certainly free to try. It's going to be very difficult, given that ours is fairly well established and has lots of guns.
You can try buying an oil platform and maybe naming it Sealand or something of the like.
You could try it. It's worked for some out there.
For a time.
Now that Charles is king, though, he's going to put an end
no more
to
Sealand
and destroy the rebellion.
Anyway, I just thought that was it made me raise an eyebrow and several things that he said throughout the entire podcast.
That's pretty bad.
The idea of attesting it as being
bad.
entirely constitutional is one of those things where I come out and just, it gets my goat, right? Grinds my gears.
Yeah. And put a little asterisk next to that. Not actually.
This is constitutional. Not actually constitutional.
except that at its core, it's just sort of ignoring the Constitution. But whatever. All right. So, all right, folks, that's it. Once again, unfortunately, we've got to end everyone's favorite segment of this podcast. So, boys and girls, go back to your lives and with this newfound information about our system of government and the rule of law and the laws of the United States, go and tell your friends about it. Have them listen to this podcast too. We could use more ears. Almost said eyes, but really ears. It's a podcast. So yeah, have them listen next week. But that's all for Captain Kangaroo Court.
Well, I believe, what have we covered today? We have really done the full scope. We have looked at some interesting cases that were coming up on the docket with Chavez, United States, and Ruiz versus Massachusetts. We
could substantially affect rights of the accused. So
some interesting criminal justice procedures there. And then we ended it all with a little Captain Kangaroo Court. So thank you, everybody, for listening today. Please take a look at our YouTube channel. We have some excellent videos coming around. I believe that we have some new Ask an Attorney videos in a new format.
We actually got a new host on Ask an Attorney this week because John and David were both unavailable. So actually the other Alex, my legal assistant, ends up hosting Ask an Attorney. Check that out. And Eric, thank you so much for filling in for David today. You make a much better David than David. So we may
That's
have
for
to
the
do this
audience
again.
to decide. We'll post a poll on our Facebook of who you want to see on the next. No, I'm just kidding. I will fill in. I'll
do
fill
that.
in as
Why
a
not?
warm body
Yeah, on the Facebook
our
podcast
current
page.
our actual podcast host, not the acting podcast host. I believe is taking a journey to England right now to pay his personal respects to the Queen.
Yeah.
God rest her soul.
Yeah, that's why he's going to school there. So he recently got accepted to the University of Edinburgh. He's in their doctoral program over there.
Edinburgh.
Gonna be getting all smart so he can help us out even more over here at Lex Rex. Why he's learning from Scots, I don't really know, but that's the path that he's chosen. So that's where he is right now. We're gonna have an 8-hour time difference, so it's gonna really inconvenience us to get these recorded in the future. So you're welcome.
Well, I'm sure that he'll come back with some fancy new ideas and some fancy new legwear.
I'm sure.
Don't forget to check out our website, lexrex.org. If you like what you're hearing, if you find it educational, if you think that other people should be listening to it, and you want to expand our reach as well as empowering us to better defend the rights of really all Americans.
Working with
Yeah.
us, really. Yeah,
Yeah.
working with us. If you listen to this podcast, you are working with us. You're part of the struggle, because half the struggle is for education. If the people know the Constitution of the United States, that's half the battle to defending it. So thank you for listening. You are part of this fight.
Excellent. And then, we also have T-shirts and books that are available for donations on our website. Keep an eye out on some events that are going to be published about coming around the bend. And with that, I believe that we can set off and leave you all on this Monday.
Yep, that's right. It feels weird because we're not recording on Monday. But we'll see you folks next week. Thank you for listening.
Take care.